you everybody for coming to listen to this. As I was telling you, some of you before we started, I'm not sure the level that you'd be interested in hearing about this subject. So I'm going to divide into three areas. First is a really general sort of look at medical inadmissibility, where it fits into the Immigration Act, how it works, what the doctors do, all that kind of stuff. The second part will be sort of some of the more important issues that have come up in the Federal Court Trial Division, cases that I've argued, and other cases before the court, particularly since last year with the Court of Appeal decision. And the third part, I'm going to look at individual assessments, which is, since Hillowitz, become a really important part of medical admissibility cases, and what makes it extremely difficult now for medical officers on excessive demand for social services to reject a case. In fact, we're having a lot of success in winning medical cases, where in the past we haven't done that. So, the medical assessment process and under IRPA is divided into sort of two sections. One deals with something, I guess you'd call risk. The other deals with something called excessive demand. The risk are things like danger to the public and danger to public safety. There are rare cases that come up on that subject, but in something called the Designated Medical Officers Practitioner's Handbook, which is now sort of a little bit of the Bible for medical cases, they do outline some of the issues they look at. So people with active tuberculosis, for example, or active syphilis,